Well, now I'm excited to tell you that our first speaker is our district attorney. Joe Hendricks was elected as district attorney for the Appalachian Judicial Circuit in 2004. And he was assistant DA serving under Roger Queen from 1995 to 1998. He was also in private practice in Canton from 1998 until taking office. Joe lives in Pickens County with his wife Kay, and has since 1995. He's a member of the Mount Hope Community Church, where he's also a Sunday school teacher. And I'd like you to welcome our district attorney, Joe Hendricks.
Well, I want to tell you, first of all, how much I appreciate being here. This is my first Pickens County Tea Party meeting. I've been to the Fannin County and the Gilmer County meetings. I just haven't been to one in my home county. The Appalachian Circuit, by the way, includes Pickens, Gilmer, and Fannin counties. So I have 3 counties that I'm responsible for as district attorney. And I told Susan, she told me the time I had, and that given the fact we're coming off Constitution Day, I said, well, I have a different topic for tonight. Usually I come to a group and I talk about the district attorney's office. But I got to have some fun with this topic, and especially it worked off with some of the, it kind of came off or out of some of the things I talked about on Constitution Day, and I wanted to talk about the topic that was given to me was American law today. Well, I want to tell you, I'm a big fan of history, and I'm a big fan of legal history, and I'm an amateur at it. I'm not a professional legal historian, but I've done a lot of reading about it, and I thought I would share some things as one amateur, maybe talking to some other folks who may have a less than expert level of knowledge of history. So if you're a college professor and your expert is legal history, you may want to get up and leave, please. But I want to talk to you today about some things I felt that sort of touched me, especially in light of sort of our constitutional situation today. And I wanted to talk about, the title of it, can you bring it up? It's The Ancient Origins of American Liberty and What It Means to Us Today. I was reading a book by Michael Barone. How many of you have heard of Michael Barone? He's been on television. If you've watched Fox News, he's been on television. Michael Barone is an excellent political writer, and he's very good on issues of relating to the Constitution and the different branches of government. In fact, I took a course in not law school, but at Berry College on the president, basically focused on the presidency. And we used Michael Barone's book. And he talked about, the book that I've been looking at and reading is it's America's First Revolution. And our first revolution, it uses the word our collectively, and it's about the Revolution of 1689. How many of you have heard of the Glorious Revolution or the Revolution of 1689? About 4 or 5. All right. We're going to talk about a little bit about that tonight and some of the other things that really are the basis or the origin of the ideas that our founders used in developing the Constitution and in developing the principles that they laid out in the Constitution. And we're going to see how our Constitution is an ingenious document, and the way it was put together was great, but a lot of the ideas that they put in there are very old. And we're going to talk about why it is that they were so upset with the British Empire that we pulled away. So I want to talk, first of all, I got to point it at something in particular. Is it on? I may need to turn it on. Okay. All right. Now I have, if you can tell me who that is. Who in here can tell me who that guy is? All right. How many of you ever watched the Disney version of Robin Hood that came out in 1973? Now can you tell me who that guy is? Who can tell me? King John, that's right, King John. This This is before he became king. He was Richard's younger brother. Y'all heard of Richard the Lionheart? If you watch Robin Hood the movie with Kevin Costner, you'll know who Richard the Lionheart is. Well, Richard the Lionheart was off fighting the Crusades in the Middle East, and they left his sorry brother, Prince John, in charge. Well, Richard ends up dying at some point, and guess what? He has to sign the Magna Carta. Now, the Magna Carta is a really important document. I don't think we realize how important the Magna Carta is. If you go to see the actual Constitution in the Archives building, you know, the Constitution is laid out there with the Declaration of Independence. Over to the side is a copy, one of the very old copies of the Magna Carta. And it's borrowed from over in England, but it's kept there for an important reason, because our early concepts of constitutional liberty are found in the Magna Carta. This is real slow. This is slower. No freeman shall be taken or imprisoned or deceased, that means grabbed hold of his freehold or liberties or free customs, or be outlawed or exiled or in any wise destroyed, nor will we pass upon him or condemn him but by lawful judgment of his peers or by the law of the land. And we shall sell to no man. We will not deny or defer to any man either justice or right. You know that's still part of Georgia law today. There's a statute it's in the first title of the Georgia Code that says the law, common law of England as it existed at the time of the Revolution is the law today. And that part of the Magna Carta is still part of our law today. And you know what? Does anybody tell me what that means? Anybody got an idea of what that means?
Due process.
Due process. You're absolutely right. It means one more thing. We will not condemn him but by lawful judgment of his peers. What does that sound like? Look at the U.S. Constitution. The trial of all crimes, except in cases of impeachment, shall be by jury. And the Fifth Amendment says no person shall be deprived of his life, liberty, or property without due process of law. 1200s, 1789. Now read that and tell me. I got a lapel pin for somebody to tell me what this means. You have my lapel pin. No, scutage. I'll give you a hint. Scutage, in medieval times, a vassal owed service, military service, to his higher up. Now you could get out of that if you paid scutage. So what is that? What do you call that? Well, not a bribe, but it was a form of taxation. It was a form of taxation. And you can't do that unless you issue letters of summons. And the summons for a particular day, and these people come together when summoned by the king to do what? Talk, and we get Parliament. This is the forerunner of Parliament. This basically means no taxation without representation in the 1200s. Okay. This worked faster on my computer because I'll use less animation today. No imposition of taxes or imposition of military service without the consent of the King's Council, which was the forerunner to Parliament. U.S. Constitution. Congress shall have the power to lay and collect taxes, duties, and imposts and excises, and to pay the debts and provide for the common defense. So, the king, even in the 1200s, had to get consent of what was essentially the forerunner of Parliament. Just like today, the president must have the approval of Congress in order to impose taxes. The Magna Carta committed the king to govern the land according to the law of the land. It required that the appointment of judges have some independence. One of the complaints was that King John insisted that the court be in his presence. They said, no, you got to appoint judges and have them go out. We can't just follow King John around to get our case heard in court. And it required the consent of the realm for the imposition of taxes and military service. So you can see that 1,200 years ago, there was a struggle between the people and the executive. And that resulted in, of course, a big showdown, and at the Meadow at Runnymede, King John was essentially forced to sign a charter that acknowledged those rights existed. The interesting thing is it's referred to as a grant, but the important thing is it refers to all of those rights and privileges of the people as having already existed. He didn't grant them to them. They were theirs to begin with, and the reason he was forced to sign the charter is because he had abridged them. And they were the customs and traditions and the law of the people, and he had violated them. So he was forced to sign this charter and acknowledge that the king had to govern according to law. We're going to learn about how that's important in a little bit. The next historical event I want to talk to you is the Glorious Revolution of 1689. James II abdicated, was run out of the country, and Parliament installed William of Orange and Mary. And if you've heard of the William and Mary College, that's William right there. He was the Prince of Orange, and he was the kind of the chief guy in the Netherlands Low Countries Confederacy or Republic. And he came over at the invitation of Parliament after they ran off this guy, James II. Now James I, you know who James I was, right? King James Bible. James II, he did some things that really upset people. One of the first things he did is he obtained a ruling from the court that the common law allowed him to dispense with acts of Parliament. Now we're talking about what things, as you as a Tea Party and as a Tea Party organization, what have we been upset with lately? The abrogation of acts of Congress. The law was ignored. Can anybody think of a situation where the law may have been ignored by the executive branch? If you can, raise your hand. All right. They were upset at James about this, and there were a number of things. The Test Acts, different things that he had done. He also established a standing army without the consent of Parliament. He imprisoned and prosecuted persons who petitioned or complained to the Parliament about what the government was doing. He imposed taxes either without the consent of Parliament or in a manner that was not authorized by Parliament. And he disarmed the people who were opposed to the king's politics. I don't know. I'm trying to think of something that might be familiar with you today. I might have to help you. Excessive bail in criminal cases, and excessive fines and cruel and unusual punishments in criminal cases. So, they ran him off. They installed William and Mary. The first thing they did was establish, and I'm sorry for this, it worked fast. I've got a Mac, it worked faster on my Mac. They established the English Bill of Rights. Okay, it works faster here. The first thing, in the English Bill of Rights, it says that it is the right of the subject to petition the king, and all commitments and prosecutions for such petitions are illegal. What do we have? The First Amendment makes it, Congress shall make no law abridging the right of the people to petition the government for redress of grievances. That wasn't new. That was old. And they believed in it. And what they were upset about, in 1776, what was the government doing? What had been happening? The colonists had been sending petition after petition after petition to the king and Parliament in London. Fix this, fix this, fix this. And they had been ignored and punished for it, and they were upset by it. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or any other place out of Parliament. What do we have today? Article 1, Section 6. Members of Congress shall, in all cases except for felony, treason, felony, and breach of the peace, shall be privileged from arrest and privileged from any speech or debate in either house. They shall not be questioned in any other place. So the speech and debate clause was established in 1689. They brought that with them. And what were they upset about? A lot of them in the Revolution prior to the Revolution were being, they were not being treated properly. They were treated badly by the government because in their colonial assemblies they'd spoken out. So we want to make sure that in Congress that our members of Congress have the freedom to say what we sent them there to tell the government. Excessive bail ought not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Eighth Amendment to the Constitution, what does it say? Same thing. What did I do? All right. The pretended power of dispensing with laws or the execution of laws by regal authority, as it has been assumed, is illegal. The President shall take care that the laws be faithfully executed. I'm just saying. Anybody think of any laws that have not been faithfully executed? I have a friend, former assistant district attorney who worked in my office, federal immigration judge. We have conversations, but one of the things I've learned is that we've just basically said that we're not enforcing half that law, essentially, unless you're charged with a crime. And you know, whatever you think about it, whatever your opinion about what ought to happen to folks who come here who enter in an unauthorized manner or stay in an unauthorized manner, the bottom line is there is a law. It was passed by Congress, and the President's constitutional duty is to take care that law is faithfully executed. Which, by the way, I see as part of my job on the state level and as a state officer. Now, we had the English Bill of Rights a couple of years later. Queen Anne took, and they had some issues that they needed to address. Look at this. No person who has an office under the monarch or receives a pension from the crown shall be a member of Parliament. Article 1, Section 6. No person holding any office under the United States shall be a member of either house during the continuation of office. Why is that important? That the executive not be able to give good jobs to people in Congress. It's a conflict of interest. They saw that back then in 1701. In 1789, they said we need to keep that because a lot of times what was going on is essentially the monarch was buying off votes. Probably need to do some refinement on that to continue dealing with some of those issues. But judges' commissions are valid during good behavior, and if they do not behave themselves, they can be removed by both houses of Parliament or one house. And I had to cut that off because it didn't fit. There are some judges who, at the time, were members of the House of Lords, and that's why some, if you remember the House of Lords, you could be obviously tried by your peers. Article 3, Section 1, the judges in both the Supreme and Inferior Court shall hold their offices during good behavior. Why is it important to have judges who are independent of the President? Or, on the other side of independent from the King? Conflict of interest, yeah. If you thought your job depended upon pleasing the King or the President, that wouldn't be good. Of course, in the state level, we elect our judges, which is a little bit different. They weren't really thinking about that back then, but we brought that into our Constitution. So we got the Act of Settlement, we've got the Bill of Rights, and we've got Magna Carta. Now, how many of you, if you were Abraham Lincoln, let's think of some lawyers that we would respect back in the 17 and 1800s. Who would you think of?
Jefferson.
Jefferson, absolutely. Lincoln, some of you, I've heard some debates.
Madison. Was it Madison?
Madison. Adams. John Adams. Who do you think, what law book do you think they studied law from? They did study the Bible. They're all very versed in the Bible, but particularly
English common law.
They study the English common law, but there was a particular author that they read.
John Locke.
Huh?
John Locke.
Locke was a philosopher, not a legal. Blackstone. This guy right here, Blackstone. Sir William Blackstone. And this is what Blackstone wrote in I'll tell you in a second, I can't remember the date, but the king has a prerogative. Just as we would say the president or governor has prerogatives. In all things that are not injurious to the subject, for in them all must be remembered that the king's prerogative stretches not only to the doing, not to the doing of any wrong, for the king can only act according to the law. And that's actually, I took out the Latin, but that's a translation of it. And here it may be some satisfaction to remark how widely the civil law, you know what he's talking about there? The law on the European continent. The law that came down that basically turned into the Napoleonic Code. The Napoleonic Code in those civil law countries differs from ours in regard to the authority of the laws over the prince. Because in the continent, who's over the law? The government is actually over the law and is thought to be the giver of the law. It is a maxim of English laws we've seen from Bracton, who, by the way, was a counselor to Henry III, who was King John's son, that the king is subject to the law because the law makes the king. Now, how is that different? They go on, it says the imperial law, which is the civil law, that basically said that the law is a subject of the king instead of the other way around. What's the difference in our law and the law we've inherited, where law comes, where the authority of the government comes from the law, and the law doesn't come from the government? What's the difference?
Well, it's huge. Napoleonic law. The government is outside and above the law.
Yeah.
And with our law, the government is constrained or limited by the law.
That's right. The government is limited by the law. Now, let's go back to 1760s, late 1760s, 1770s. What were the colonists upset about?
Taxation.
They were upset about taxation. The French, y'all remember the French and Indian War? Oh, y'all don't remember it, but you probably read it. We had to, or maybe somebody, one person here might remember the French and Indian War, but French and Indian War, the British had to come over here and fight, help us fight the French and the Indians. And it cost a lot of money. And so they wanted to recoup that. And if you read, there's a good biography on Benjamin Franklin by H.W. Brands. It talks a lot about the intricacies of it. But, and the colonists knew they were going to have to chip in some on this. But they said, you either got to give us representation in Parliament, or you're going to have to go through our colonial assemblies, because what have we known since the time of Magna Carta? Exactly, no taxation without representation, and the king is not above the law. The king must have the consent of the governed in order to collect taxes. And what you look at is from a continuum of English history, from the time of William the Conqueror up and through the time Parliament really takes a foothold. What did the king have to have in order to get enough revenue to run things? He had to call the Parliament in. And you know what Parliament would say? No supply without redress of grievances. So the king would redress grievances. They'd get a little supply. A couple of years later, the king needed more supply. Parliament said, no redress of, no supply, which meant taxes, without redress of grievances. And so eventually the Parliament became strong enough to kind of stand on its own. And so we have a government of laws and not of men. I talked about a bunch of English guys for a long time. Who's that? John Adams. We hold these truths to be self-evident, that men are created equal, and they are endowed by their Creator with certain unalienable rights that are among these, which means this is the first three among many are life, liberty, and the pursuit of happiness. When he says liberty, he's thinking about the rights and privileges that the Englishmen have had for centuries. But he says something new, that they are, that who do they belong to? Not just Englishmen, but who? All men and women. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government, or from the consent of the governed. So what's first? Rights or government? Rights. Why do we have government? To help us to secure our rights. And so, what is it about today? And I don't want to talk a whole lot about politics today. But we must remember and keep reminding those in authority that government, we didn't institute government for you to take care of us. We instituted government for you to protect the rights that we have given to us from